So there are restrictions all over the place, and intentionally so.
My lord,
So that if an appeal is to be provided where the lawmaker or the framers of the constitution consciously, deliberately did not provide one, then the matter should go back to them, and under the new circumstances, if they consider it appropriate, they can amend the constitution and specifically provide an appeal. Using supplemental powers or using ancillary powers, I mean, that is, I think, stretching the constitution much beyond what it
my
is
lord,
originally
my response to
designed
the latter questions is there is no bar under Article 199. There is no bar under Article 185. There is no bar under Article 184(3) that you can't provide an intra-court appeal through an ordinary statute. There is no bar.
Mr. Faisal Siddiqui,
Where is the bar?
where the language used is express authorization. That is the bar.
but
You have to have express authorization within the constitution in order to utilize
What more
the
express
powers
bar is
available.
required than Article 175(2)?
Mr. Faisal,
175(2) does not confer
Mr. Faisal
legislative
Siddiqui,
competence.
if I may add to what my learned colleague is saying, see, it seems to me that the proper context of this sentence from this judgment at page 293 that you are so strongly relying upon, and with very great respect, I think you are taking it out of context. But anyway, I think that is perhaps expanded upon at page 295.
सर
Kindly
पैरा
उसमें
अगर
जो-
बता दीजिएगा.
पेज 295
Sir,
वो पैरा 63 इसमें जो अंडरलाइन पोर्शन है ना वो जरा देखें. इसमें एक जजमेंट सुप्रीम कोर्ट की रेफर्ड टू है और उसके बाद उसका आई डोंट नो वेदर इट्स कोटिंग फ्रॉम दैट जजमेंट, इट्स कोटिंग फ्रॉम अ जजमेंट. वो उसमें देखिए जिसको पैरा अंडरलाइन किया हुआ है जो
जी वो 2000 SCMR जो कोर्ट की
उसमें उसके अंदर शायद दैट एक्सपोर्ट्स दैट 175(2) पॉइंट इन प्रॉपर कॉन्टेक्स्ट.
Yes.
पढ़िए तो सही, सुखानी पढ़िए. ये जो अंडरलाइंड है ना,
Under entry 55 of
अंडर
Federal List.
55 ऑफ द फेडरल लिस्ट.
Sir, I'm sorry, I actually have the
Page 295 जहाँ
अगर आप
63
पैरा
में
kindly अगर
reproduce
बता
हुई
दें.
हुई है ना,
पैरा 63 का सेकंड
पैरा 63
सेकंड कॉलम थर्ड पैराग्राफ.
इसमें if the entry
If
55
entry 55 was not there in the FLL, it could be argued that Article 175(2) of the Constitution in respect of matters relating to cooperative societies exclusively failing under the competence of the provincial legislature, a law can validly be made by the provincial legislature, enlarging jurisdiction of the Supreme Court and conferring on it supplementary powers. But Article 175(2) is not to be interpreted in isolation. It has to be read and interpreted along with Article 142A and the entries in the legislative list. Under entry 55 of the federal list, federal legislature is competent to make laws regarding jurisdiction and powers of all courts except Supreme Court with respect to any of the matters in such list. The other part of the entries makes the federal legislature competent to make laws enlargement of the Supreme Court and conferring thereon the supplementary powers with the proviso that this is to ascend is expressly authorized or under the Constitution powers and jurisdiction conferred on the Supreme Court by the Constitution can neither be inferred with or varied or taken away by legislature. However, jurisdiction of the Supreme Court can be enlarged and supplementary powers can be conferred on the Supreme Court by law in view of Article 175(2) of the Constitution, and entry 55 read with Article 142A of the Constitution leaves no doubt that such enlargement of the jurisdiction and conferment of supplementary power can only be done through law made by federal.
So this is the point, I think. This explains the context of what that sentence says, because what this passage is telling us is that the jurisdiction of the Supreme Court can be enlarged. 175(2) does not bar that, but for that there must be validly enacted law, for which you have to look not to 175(2) but to entry 55 read with the Article 142A. So this is the context.
142A says you look at the entry.
That's what I'm saying.
Yes.
The two have to be read together.
Yes.
But what this passage makes clear is
Yes.
that 175(2) is not a standalone power conferring jurisdiction, because at the beginning of this para, the Supreme Court gives the example, if that were so, which is what I also put to you, then law could include provincial law, and therefore a province could say, well, we enlarge the jurisdiction of the Supreme Court. Supreme Court is saying, no, that is not correct. That 175(2) is not independent. All that it tells us is, yes, a jurisdiction can be conferred on any court, including the Supreme Court, by law, but that law has to be 55 and 142.
142A. There is no other third provision which is cited for the Competition Act.
लेकिन आप जो कह रहे हैं ना, जो आप जो उस जुमले को जो पढ़ रहे हैं at page 293 पे, as though that is intending to give a standalone competence in terms of 175(2), I don't think that's correct.
Mr. Faisal Siddiqui, if I go along with that, actually, so therefore, I don't understand how Competition Commission can confer a jurisdiction on the Supreme Court.
That's a big problem.
Unless it cannot, because it has to be, we have to pass through the same test as we have to pass today, that is expressly authorized or by or under the Constitution. So if 175 is out, then where is that expressed for, even for Competition, Election Act, for the other four different statutes?
There is
as well as
also a law,
184?
Faisal Siddiqui Sahab, there is also a law, Newspaper Employees Condition of Service Act 1973, in which also the appeal is provided direct to the Supreme Court. There is no appeal in the High Court, but it is against the conviction awarded by the Implementation Tribunal. So this is also direct appeal under Section 13A of the Newspaper Employees Condition of Service Act 1973. So Competition Act, Newspaper Employees, Contempt of Court, there are three laws at least.
Since nobody has given me the background, there's a Competition Commission has given authority to the Supreme Court, or the Act?
No, the Act. There is a provision, Section 44.
And the argument from the other side is, since it is a provincial act, it cannot confer such jurisdiction. Is this the argument?
Sir, मैं हाई कोर्ट में नहीं था, इसलिए मैं ज़्यादा कहना नहीं
लिखा क्या जजमेंट में उससे?
उधर एक ऑब्जेक्शन ये ली गई थी पिटिशनर्स की तरफ से.
One of the objections was how is a direct appeal provided in the Supreme Court.
So
The other was also about who has legislative competence,
It was
whether the
about
federal.
legislative competence.
Yes.
And in that context, the rest of the provisions of the law were challenged.
Yes.
And so the judgment aims to show how the subject of competition falls under the legislative list, and therefore from there derives power to.
Mr. Bhandari, were you the counsel in this case? Can you just explain me don't argue the case, just explain me the fact of this matter. What was the objection taken?
Well, to this particular provision, the primary objection was that under the scheme of the Constitution, the High Court can't be bypassed in the appellate hierarchy. So the first appeal must be provided to the High Court under Article 185, to the High Court, and then from the High Court's judgment, the appeal should come to the Supreme Court. What has happened is...
So that was the case.
That was the...
वो बाकी बातें नहीं, मैं सिर्फ I was just trying to understand the fact.
On the question of appeal, that was the primary argument.
Just 1 second. Now, since the matter of competition, right, since goods travel across borders and that's specifically permissible, mandated by the Constitution, now if different competition commissions, even let's say there are 4 or 5 competition commissions in Pakistan, and matters start going to the High Court for different determinations, would there be fundamentally anything wrong if a province, for the sake of argument, or all the provinces confer the jurisdiction on the Supreme Court?
My Lord, under the scheme of the Constitution, that can only be done through Article 144. Yes. All the provinces will have to pass resolutions for an Act of Parliament to be framed in terms of Article 144, and then that too would have to pass through the test of Entry 55.
Draft में.
So that could be done.
There is a possibility. The Constitution provides a way out for that.
Okay, just wanted to understand it. Thank you.
Entry 55 problem would remain in terms of appeal to the Supreme Court.
Yes, that
As
remains.
opposed to Parliament making a competition law is a separate question which could be addressed by 144. But the question of an appeal from appellate tribunal to the Supreme Court, that would still be.
तो फिर एंट्री 55 के टेस्ट को फिर भी मीट करने पड़ेंगे, मीट करने पड़ेंगे।
Entry 55 is
जी, वो तो
still in
करने
the way.
इसका मसला solve
144 में भी जाएंगे तो एंट्री 55 के थ्रू गुजरना।
वही फैसल साहब से पूछ रहे हैं कि एंट्री 55 का टेस्ट क्रॉस करें ना।
Faisal Saab,
You are express authorization
Faisal.
पे बात नहीं बढ़ रही।
I have two questions. If 175(2) is read with entry 55, is that not sufficient authorization expressly given to the Parliament? Second question is that the expression used in entry 55 is enlargement of jurisdiction. Can you give an example how the jurisdiction, there are basically 3 different jurisdictions of this court under the Constitution. How can the jurisdiction be enlarged? Any example?
Sir, appellate jurisdiction enlargement, one of the forms of enlargement of appellate jurisdiction to me would be creation of a new appeal. I mean, how can that not be considered as an enlargement of appellate jurisdiction? I mean, your lordship is going against the settled principle of interpreting
Counsel,
an entry, which is a very narrow meaning given to a word in the entry.
If an appeal was provided or envisaged under orders passed under 184(3) in the Constitution, yes. Now conferring a jurisdiction would essentially mean you are amending the Constitution.
Where is the bar in 184(3) that no appeal can be provided by an ordinary statute?
Why don't
Where
you?
is the authorization?
Learned Counsel,
When you need to provide an appeal or an enlargement, you have to fall on entry 55.
Yes.
And entry 55 says there has to be an express authorization. So that takes care of where is the bar. The bar is there because it says you have to have express authorization within the Constitution.
Sir, I leave this point. My express authorization lies in 2 provisions. 175(2) read with Article 141, because only the Parliament can make a law which relates to the Supreme Court, because it's a federal institution. Now I move forward.
Yes, चलिए.
Okay.
आप कितना और वक्त आपके पास चाहते हैं?
Sir, I finished the competence part.
Can you just give us your own time?
Sir, I would like to
Needless to
finish.
state,
No, sir,
how many
I would-
questions?
I'll finish in an hour, sir. If your lordship may kindly
So
give
we
me.
can either take a break and come back.
Yes.
Is
Mr.
this a good?
Siddiqui, Article 10A has any connection with conferring power to the Supreme Court regarding appeal?
Sir, I would not like to go down that route that fundamental rights can be used in order to conferring legislative power, because fundamental rights are just so widely worded that the entire legislative list will disappear if that interpretation is
10
taken.
past 2 we will convene
जी,
again.
जी, sir.
ठीक है, 10 past 2.
Thank you, sir.
Thank you.
अच्छा पता कीता तैयारी बैठे बढ़ते मैडम कितनी देर बाद ले गया करनी है क्योंकि अभी ये रेफरेंस